Principal Dr. A.S. Bullet. I request Dr. A.L. Bullet sir, please welcome our resource person, Dr. Suhas Kulkarni sir. I request Dr. Raut sir to please welcome our another resource person, Dr. Aniket Gade sir. Recently, I read one column from the Economic Times. Now, in that particular column, I read patents. Headline is just like that. Patents granted in India tripled in last 5 years. So still a fraction of China and us. Okay. So the increase in patent filing boosted Indian ranking in the global innovation index from 81 in that 81 in 2015 and 46 in 2021. So that is 30% rate of filling in intellectual property rights in for example patents in India. According to the survey, the average time taken for a final call on granting a patent in India in 2020 was 42. 42 months, actually 42 months are required for the to call a particular patent. But when we compare this 42 months with the other countries like US, the 20 months are required for to fill the patents. And in China, near about 15.8 months are required. But when we talking about the South Korea as well as the Japan, only the 15 months or the only 1 year is required. So this is a discrimination. Now today we discuss about the filling of patents as well as the intellectual property rights. So I request our IPSC coordinator, Dr. Ashish Rao, for his introductory remarks.
First of all, I pay my sincere tribute to Chhatrapati Shivaji and Dr. Punjab Rao alias Bhausaheb Deshmukh, founder president of Sri Shivaji Education Society, Amravati, Honorable Dias, Honorable Principal of our college and Chairman of this workshop, Dr. A.L. Kulkarni sir, respected resource person Dr. Suhas Kulkarni sir, and guest of honor Dr. Aniket Gade sir, our RAC coordinator of our college, Dr. Deepak Koche sir, all IPSC members, all head of the faculties, head of the various departments, faculty members, research students, and PG students, and also the participants who join this workshop online and offline. I welcome you all on behalf of our college for the one-day workshop on IPR awareness, organized by Sri Shivaji College of Art, Commerce, Science, Akola, in collaboration with IPR Safe Sant Gadge Baba, Amravati University, Amravati. Let me highlight our college. Sri Shivaji Education Society, Amravati, Sri Shivaji College of Art, Commerce and Science, Akola, is situated in Western Vidarbha region of Maharashtra and affiliated to Sant Gadge Baba, Amravati University, Amravati. Sri Shivaji College of Art, Commerce and Science, Akola was established in 1963 and is going to complete 60 years of its gracious year of its existence in 2023. It was initially imparting only formal education in Faculty of Art and Commerce. Later on, by considering the importance of science and technology, the Faculty of Science was introduced in 1967. The institution offers BA, BCom, BSc and DSc Home Science, along with PG in 21 subjects and PhD programs in 15 subjects, and 12 career-oriented courses in Art, Commerce, Science and Home Science. As a college, we can proudly say that it has indeed grown from a seedling into a tree. In its continuous efforts to impart quality education Sri Shivaji College, Akola, was re-accredited with A grade with CGPA 3.24 in third cycle of NAC. The college has also earned a special reputation for being conferred with the status of college with potential for excellence by UGC New Delhi in the first phase and in the second phase up to 2019, and recognized as a lead college status by SGB Amravati University Amravati. The college has been also supported by funds from Department of Science and Technology, Government of India under DSP KIST program. Also, our college is ISO certified. Up till now, there are 100 students have been awarded PhD degree from our college, and 18 major research projects and more than 135 minor research projects have been completed and sanctioned from UGC, DSP, BRNS, ICSSR, etc. During the last 5 years, more than 500 research papers have been published in record, UGC listed, and Scopus Index journals. Also, 3 Indian patents are sanctioned to our faculty members. As this workshop is on IPR awareness, and our research is more than we can publish 500 research papers. But what what is the benefit of that research to society, and how this research will convert into the patent that will this type of information will be provided in this workshop. So once again, I welcome you all, and I'm sure that this workshop will definitely prove you useful and beneficial to all of us. Thank you. Thank you very much.
Thank you, sir. Uh, Dear participants, for today's workshop, we have two eminent speakers as well as a resource person. For the introduction of the resource person, I would like to call Dr. Deval Deshmukh for the introduction of speakers.
Thank you, sir. So good afternoon, the dignitaries, faculty members, and students. It's a great pleasure for me to introduce our speaker today, who is going to talk to about intellectual property right awareness. Dr. Suhas Kulkarni has been chemistry from Dr. Babasaheb Ambedkar, Marathwada University, Aurangabad. Further, he did PhD in organic chemistry from the Institute of Science, Mumbai. Later on, he pursued Dr. Kulkarni is working as the Assistant Controller of Patents at Office of Controller General of Patents, Design and Trademark, Mumbai since December 2015. Prior to joining this position, he worked as Examiner of Patents and Design. Working has more than 18 years of experience, significantly dealing with IPR as a patent expert in the field of pharmaceuticals, chemistry, agrochemicals, etc. Dr. Kulkarni is a member of several prestigious organizations like Asian Middle East Association of Chemists, Indian Science Congress, Indian Council, Indian Chromatography Society, etc. Sir has played a role and responsibilities like identifying the patentability, novelty, and invent in an invention disclosure and union, then impregnated analysis, handling high court matters, and managing priority of them for chemistry, biochemistry, pharmaceuticals, systems. Dr. Kulkarni has a key skill in managing various prestigious various presentations of the research papers at various workshops, symposia, Indian Science Congress, Indian Chemist Council, research scholar meets, etc. He has owned 5 patents in the field of organic chemistry and chemical engineering. He is also visiting faculty at the Institute of Intellectual Property Studies, that is IIPS Mumbai, and Patent Gurukul Mumbai. Dr. Kulkarni is one of the best speakers in the country and has several prestigious universities as well as institutions to share his knowledge in chemical topics. We are all very pleased to have Dr. Suhas Kulkarni here today to discuss the topic intellectual property. Let's give a warm welcome by clapping. We are fortunate today to have another guest or another resource person, Dr. Aniket Gade sir. He is the coordinator of IPR Cell, Sant Gadge Baba, Amravati University. So Dr. Gade sir has done MSc and PhD in biotechnology, and interestingly, he has done the postdoctorate also from one of the reputed institution in USA. Sir, having area of specialization in bio-nanotechnology as well as bioinformatics, with a teaching experience of approximately 20 years. Dr. Gade are honored uh, with several awards and honors like INSA Summer Research Fellowship, Young Scientist Awards, etc. Dr. Aniket Gade having several international collaborations and consultancies. On the other hand, Sir has published more than 85 publications in reputed international as well as national journals and have also having 18 book chapters. Sir also having a number of completed and ongoing projects from the various funding agencies like UGC, DST. We are again fortunate to have such a magnificent personality with us. I would like to welcome Dr. Aniket Gade sir with a huge round of applause. Welcome, sir.
Thank you, Dr. Deval. So, dear participants, we are eagerly waiting for to hear the thoughts related with the patents as well as the intellectual property rights. So, first I called Dr. Aniket Gade sir for his valuable thoughts.
Thank you, sir. So, dignitaries on the dais and off the dais, I can understand it's already been late to initiate the program as per schedule. So, the thing is, the aim is to hear from a person who is at the patent office, because I'm being an academician, have got the things clear with respect to academic point of view, but there is some technicalities which have been involved that can be addressed by a person from the patent office. So if I keep on talking, we as a lecturer have got a habit of at least 1 hour once we start, but I'm not going to take much of your time, but would like to tell few things, like two things which I'd like to say. One, as a representative of IPR cell of Amravati University, I'm here. So any particular thing which will require related with the IPR, there is a IPR cell, and we'll try our level best how we can help to go for filing of any intellectual property rights. So anything if you need will be there, and we'll try our level best. This is one. Second thing, there is one important amendment which has been done with the patents, is that earlier it was not possible to go for the patents by the name of institute. We could go for, but the fees was very high. At least fees was at least 5 times higher as compared to filing a patent by individual. But now this fees is at par. That means the fees has been reduced. So it's been possible that if sir decide, they can go for filing the patent by the name of a college, where the faculty can remain as an inventor. So both can be benefited, and probably it's possible to go on and even to show that how much intellectual property is available by the name of a college, for which naturally the things are required from the math point of view and other things which will be useful. So these are the two things. So without taking much of a time, I would like to thank Boche sir for at least giving me opportunity to tell the things which have been available. And thank you for this. Thank you.
Thank you, sir. So I think the patent for to speak about the patent is with Dr. Suhas Kulkarni, sir. So I called Dr. Suhas Kulkarni for his resourceful thought.
really the post lunch session and talking on something is very difficult, especially when I'm not from the academics. I'll try to do as interactive session as interactive as possible because as I listened that you are talking about the time taken for the granting of patent. It means that basically you people are aware that what is the patent and what for it stands. As a principal, sir, I will give you a brief to your college stating that let the college own a startup in which the idea that from college is being utilized and you are generating actual property from the intellectual property. So let's have a dream to have a startup of your at the college. Let the college may. So that will be because it's a revenue generating model. The other countries where the academic institutions utilize limited property for creation of the technology transfer. So let's think from that point of view. Already you have been generating a lot of PhDs since quite long, and so this college. So it's not really an exaggeration that you to start on your own at college from your own ideas. Let's think from that point of view. If it is possible, then it will be an ideal model not only for from the Amravati University but the entire state or even the okay, that's a thought to share. But what for I'm today here because as a part of the 75 years of independence, my office has launched a mission to reach up to 10 lakh students to sensitize faculties to sensitize them about the intellectual property rights, let them aware about what is meant by the intellectual property rights, importance of intellectual property rights, what are different types of intellectual property rights, and especially as everyone is interested to know about the patents, when and how somebody can file a patent application, so what are the expenses required from the office side for filing the patent application. Let's discuss about that. I'll take you one by one through all of the presentation as well as all the information. Meanwhile, any one of you having any query, I will like to resolve it as it comes through. So let's have the interactive session because I don't want that. I'm already feeling sleepy, so you help me to keep it me awake and because okay, to start with the concept of the intellectual property right, I think being you are aware about the patents, that means what is intellectual property rights must be known to all of you. But still, I will say that how the patent office looks to the intellectual property, or actually what the intellectual properties are about. When it comes to the intellectual property right, these are three different words clubbed together to give the definition of an intellectual property right, or what can be called as a IPR. I don't need to elaborate on the word intellectual because I don't need to explain it also to the academicians what intellectual stands for. It's a creative minds who create something always, and that creation is nothing but the new ideas or new concepts coming in the any intellectual mind. Then it comes to the property. I'll explain your property details in a time. But what the right? Right comes for the ownership. Ownership in the sense, the legal sense, I am saying the ownership of the ownership. That means the right created or something. When you get the right, then only you have the ownership over that. Ownership in the sense you can exploit it, you can use it, you can actually use the way you like to use that. And when it comes to the property, then I think everybody of you, all of us, since morning to evening, learn to create the property. The property can be in the form of the home, it can be in the form of the land, piece of land, it can be in the form of the new cars, or it can be gold ornaments or anything which we are creating out of our hard work of day to day. So these are all things nothing but the property. And this all properties like a land, piece of piece of land, flat or plot, bungalow, car, ornaments, any expensive thing which we own is nothing but the we have the physical possession of that. That is why it is called as the tangible form of the property. Whereas the intellectual property falls under the different type of property that you don't find the physical presence of that at all because there is no physical possession of the intellectual property, whereas it is having intangible form of the property. It is in the form of the title in the name of that, credit in the name of you, but still it has an ownership certificate in the name of you being it is registered on your name. That means the ownership certificate is nothing but on the creation of your mind, creation of your ideas is nothing but the intellectual property right. The concept of intellectual property right is creating ownership over the creation of our mind is nothing but intellectual property rights. Is that concept clear? The concept is in the sense that whatever you thought, whatever you think, and you convert them into the new product or new process of ideas and have a ownership over that to convert that intangible form of the property into a tangible form of the property. Then it's called as an intellectual property right or IPR. The IPR is not only having importance in the sense having credit in your it is having importance from commercial aspects of that. That's why I'm telling you about the having the dream of a startup from the college stage. There's nothing an exaggeration of that because intangible properties only get converted into the tangible. Ideas get converted into the property. What ideas we are getting, what ideas we are developing, that ideas will be converted into a tangible form of the property. Then it is the utilization or the proper commercialization of the intellectual property rights. The intellectual property rights or whatever research work we are doing, but we are creating a new property. Unless we have ownership over it, we cannot exploit it. And we cannot exploit it in the sense that to have the ownership intellectual property, to have the ownership over the creation of our own, only you will stop others from practicing it. Unless you have the ownership on your own over the intellectual property or over the creation of your mind, you don't have the right to stop others. So that is why it is important to have the ownership. The ownership gives you the right to stop others from utilizing it without your permission. It's not only the commercial aspect that you have your own industry out of that, but you can license out such technologies. You can sell out this technology like any other properties to creating, converting that intellectual property into the tangible form of the property. That is the reason why it is so important to have the registration, have the ownership certificate over such property. I'm not here to generate a business for my own hobby, but I'm here to sensitize the mind of intellectual people, the most intellectual people of our society, to understand the importance what they are doing and to help that ideas or that creation of the intellectuals for the benefit of the society. So that's the reason why the office is there. As somebody has rightly said that the China has so many of the patent applications. USA has so many patent applications. Europe has so many applications, and Japan has. These countries are having number of patent applications. If we see, then we are standing at very different level of the filing or number of patent applications. If I tell you the exact number before a year or two, how many applications India has to India file, then if we see the Indian figure, applications filed in India, it's around 70,000 applications filed in India on the patent grant of patent. Whereas in China, it is 10 lakhs applications. Is it comparable? No, it is comparable. If you see the example of, if you see the USA, in United States, around 4 lakh applications filed per year. In Japan, 4.5 lakhs applications filed. In Europe, around 3 lakhs applications filed. Whereas we are standing around just 70,000 applications, and that too, most of that applications, more than 60%, 70% of that is coming from the overseas application, not filed by the Indian or Indian academic institutions. So that is why we are very poor in finding or having ownership of. In contrast, if we see how many publications our scientists and researchers get around the world in the best journal, your own figures, if you see that how many publications your college has and how many patent applications you have filed, so that means you have generated the intellectual property, but you distributed it. Maybe somebody in corporate using your own, you generated ideas, you generated research, and utilizing for their development. Well, you have missed out that because you have published it. Once you have published, publication don't give you any legal ownership over that. Once you publish journal, you get some credit point in your CV. That's it. Nothing out of that. But what you get when you have the patent ownership and then you publish, there is no bar to publish the research paper after filing the patent application. Not a single day you need to wait. Same day you can go for a publication. The day you file the patent application, next day you go for a publication. There is no bar for that. But you cannot do the vice versa. You cannot do the vice versa unless there are some exemptions are there. I will not go into details of such exemptions right now. But the thing is that by publications, having the number of publications, we can boast on ourselves that we have so many of publications in our credit. But what we are getting out of that, except having credit points in your CV, maybe university awarding or your government may be awarding out of that. But what is that? That's a very tip of the award you are getting apart from the credit. You are not thinking to use it as a commercial point of view. You can have your own startup from your own researcher work. The concept of having the startups. The startups are in the sense that startups are nothing but the new and newer ideas doing business. Why government is encouraging the startups so much? Because government cannot provide employment to everyone. Whereas the academic institutions have the potential to develop, to have the newer and newer ideas to develop this this particular aspect, and that is why the concept of startup is there. Okay, anyway, that's a different thing. But to understand the importance of intellectual property, right? It's not only the commercial aspect to that, but also the credit you get out of the having ownership over the intellectual property. Intellectual property is nothing but only not restricted to the only patents. Broadly, intellectual properties are divided into two main classes. One is called as industrial property, whereas other one is called as the copyright and related rights. If we see the different types of intellectual properties, which is in one which is in categorized as a industrial property, which has different intellectual properties under that. What is called the trademark or service mark or trade dress. The second one is called as geographical indication. Third one is called as third one is the designs. Fourth one is the patents. Then it comes the topography of the definite circuit. Then it comes to the undisclosed information or a trade secrets. And the other kind of intellectual property is the copyright. So we'll see one by one. I think for the trademarks, we don't need to show, we don't need to tell what for the trademark stands. We come to the trademark. आवाज येतो का? नाही, मी काय आहे आणि हा YouTube आहे. दोन्ही सुंदर, दोन्ही सुंदर. So these things we have seen the types of where in a product or different types of intellectual properties lies. If you see the particularly this example of a laptop, then how the different intellectual properties are embedded into that. The logo of the Apple is there for identification of the product, whereas the LED display is for the patents. Then the body of laptop is for the designs. Then the Apple sign is trademark. Copyright is for the user manual, and topography of integrated circuit is the layout of integrated circuit. Okay, we'll see one by one what for it stands. I think the trademarks mostly, I don't need to tell you what the trademark stands for. But trademark is nothing but a particular type of a symbol or a name associated with the product to identify the product from the competitors group. Or the service marks is to a particular name or a symbol associated with the different types of services to identify the services from the different from the competitors. So it's about the distinctive marks which are used to identify the different types of services and goods associated with the products. So in particularly, if we see the inputs of these things, I don't think I need to tell you name after seeing these particular symbols. If you see the symbol of McDonald, then it is easily be identified what services McDonald provide. Or Coca-Cola, the name of the bottle itself or the shape of the bottle itself is a recognizable sign to understand that what it contains. Whereas the Google or the Nike or the Adidas or what are the different symbols of this. These symbols are nothing but a form of the intellectual property, or these particular signs are nothing but the form of the intellectual property. In the sense, these signs help us to identify the products associated with it, and it is easy for the consumer to identify it because it has certain impression created or certain reputation created in the mind of its customer. You cannot change, you cannot distinguish the product unless you see the sign associated with that or a particular mark associated with that or particular name associated with it. Because why this constitutes as intellectual property? Because these products which has been identified with particular a symbol or a name has certain reputation about this product in the mind of its customer. For instance, if you take an example of a toothpaste which we are regularly using, every day we are using, and one day you just change it, you won't feel that freshness as you used to feel with your regular toothpaste. That regular toothpaste you identify by its name or by a symbol associated with that. You can imitate the particular name or symbol of the toothpaste which you are using. Similarly, it is been applied to the all products which has been there. All products we are using from since morning to the late night. All these products is been identified by its name or particular mark associated with that. Similarly, it is been applicable for the services also. The different types of services. For instance, the name of banks which we are using or the ATMs which we are using. Nowadays, we are not using the ATMs so frequently after the Paytm and the Google Pay. Its use is drastically been reduced. Maybe some days it becomes absolute also. But apart from that, how we identify the ATMs or how we identify the different mobile service providers? It's by a particular name or a symbols. Apart from that, there is one more thing that is been called as a trade base. How it has been packaged, how it has been presented to the customer. The packaging nothing but the good color combination or intelligent color combination of the of its cover or of its presentable things. How it has been because it instantly gives the image in the mind of customer about the product which he are going to use. So that is it is called as an intellectual property. That is the packaging is nothing but the trade dress, which is also recognized as a form of the intellectual property. And all this intellectual property is nothing but is the reputation or the goodwill of that particular products created in the customer's mind. That is nothing but the brand value of the particular product or the services which we utilize. If you see, for instance, I will give you this particular thing to identify that if you know what's the brand value of this Apple, sign Apple. Yeah. Last month I have seen that what's the brand value of this Apple. Everybody has a smartphone with them. They can Google it and find out the brand value of that. Last month it was around $355.1 billion. How much it is? It's just 50 or 50 billion less than what we are earning as a country in a year. It's 4,000. $4 billion which they are earning as a country, whereas this particular symbol, particular this, because why so much brand value the Apple sign has? It's because the reputation of product. I think in all, maybe hardly one person may have the Apple phone with him. The cost associated with this product is not so affordable as it is with compared to the other phone. The reason is that the quality of phone. The reason is that the quality of phone, the intellectual property, the creation put behind the creating this particular product is so valued. It comes the Apple, it gives the Apple sign as a value of $355.1 billion. So that's that where the intellectual property stands. How the intellectual property has been identified or the value. It's not only for the Apple as a product, it can be any product you take and it's a value. So the purpose of me is coming and interacting with you in the sense that to understand the value of creation of our man. So next time when you say that there are so many of publications you have, then please have the patent number, patent application number or patent numbers and so on with that. It will be having more value to the. Okay, these are about the science. These are about the how the trademarks look like. So whenever the application is been filed for the trademark, then it is it mentions as a TM there. When you sign, you particularly see these particular two signs there as a TM or the R encircled. Then you understand that TM means the application for registration of trademark has been filed, and R is the already registered one. No one can copy it without the permission of the owner. This is about the trademark. Ultimately, the trade secret also. Trade secret, although it is considered as an intellectual property, but it has been not protected under the intellectual property laws. It has been protected as a contract between the employer and employee. Where is the trade secret stands for the any secret formula, practice, process, design, instruments, or the pattern, commercial method, or a comparison of information, which generally known or reasonably not ascertainable by others, and by which the business can be obtained an economic advantage over the competition over the competitors or customers. This is about the trade secret. Trade secret is nothing but the secret formula or the compilation of information. In a sense, everything is been the formula has been known, but not know how it has been prepared, how it has been formulated. Everything is been disclosed, but nothing is being read out of that. For instance, example for the trade secret is the well-known example is that the Coca-Cola. Everybody know what is there in Coca-Cola, but nobody reproduced the Coca-Cola till date. The reason is that it's even the patent application is not for the trade, being it's a trade secret for the Coca-Cola or Thumbs Up. The formula is known. What is there? Caffeine is there, sugar is there, carbon dioxide is there, and a lot of air is there. But we so many outlets, so many cold drinks come in the market, but nothing is reproducible as the Coca-Cola. Similarly, it is applicable for the Domino's pizza also. The taste of Domino's pizza around the world is same. The reason is that it is a trade secret. What dough they are using, what type of wheat flour is being used, how it is being processed. The reason is that it's a trade secret. It's not disclosed. Similarly, it is applicable for the McDonald's burger also, or the McDonald's even McDonald's French fries also. It's so different in the sense that what they are using, they are not disclosing it. They are keeping it as a trade secret. It has been protected as a agreement between the employer and employer. It has been not covered under the not protected as a intellectual property under the intellectual property laws, but it is a form of the intellectual property which has been protected as a agreement between the employer and employer. That's about the trade secret, right? Then it comes to geographical indication. I think no few of you may have heard the word the geographical indication. Is it? Any one of you? What for its science? The geographical indication. As far as language is concerned, it's okay, or do I need to speak in Marathi also? I think most of the I've seen the faculties only here, so it's what were the geography? Have you heard the word geographical indications? No. Hmm? As per the definition of the geographical indication, what geographical indication stands? Geographical indication is a sign used on the goods that have a specific geographical location and the process qualities that possesses qualities or a reputation that is solely due to the place of its origin. It's not related only to the agriculture product. It can a man-made things also. If I give you two examples, then you will start on thinking that when you will hear this particular word, you will tell me. If you see any of these, may take you to the geographical indication. Nagpur oranges are known from the place because it has a characteristic taste that is developed only in the region of Nagpur. Alfonso mango or Hampus mango, which have the characteristic aroma associated with it because the place of its origin that is developed in Ratnagiri district. Kolhapuri chappal is famous being it has been prepared in and around Kolhapur. That's why it is called as a Kolhapuri chappal. Or a Paithani sari is been known for its particular, I don't know exactly what characteristics it has, but the place where from it is originated. Is it? So these are the places by which the product has been identified, and the name associated with it is a community property of the people staying in that area. It is not restricted to a particular town or a region. It can be even a name of country also. As per for instance, if you take the example of a champagne, champagne is famous from a country. Where from it is famous? France, right? I'm not aware because I never tasted it. It's from the we assume it is from France. Next time I will get myself updated over there. The grapes from Nashik is famous. The grapes which is originated in Nashik has certain color. That's why it's called as a Nashik grapes. Bananas from Jalgaon or even what is that? Brinjal, huh? Hmm? Ka? नाही ऐकलं. शेगावची कचोरी तर हे दिला मी सरांना. सर IPR त्यांचे हेड आहेत अमरावती युनिव्हर्सिटीचे आणि जळगाव सॉरी अमरावती पासून शेगाव जास्त दूर नाहीये आणि अमरावती युनिव्हर्सिटीची एक मोरल रिस्पॉन्सिबिलिटी बनते की शेगावच्या लोकांना एवढी जरी हेल्प करू शकतात की दे आयडेंटिफाय द शेगाव कचोरी ॲज अ जिओग्राफिकल टॅग because it has been not only exploited in and around Shega only. It is up to Mumbai. The people are selling kachori in the name of Shega kachori. So not only as an academic institution from this area, but being close to the Shega, it's the responsibility of the intellectuals of this area to give this tag to the people or traders in Shega to help them to protect this particular name. People are actually using that. In earlier also, I told that at least two outlets in Mumbai near my home selling kachori in the name of Shegaon kachori. So it has been developing as a brand. So it is been responsibility to protect it as a Shegaon kachori. Otherwise, elsewhere you will find out Shegaon kachori coming from China also. So it will be not an exaggeration of that. So we are conscious about that. So what the geographical indication stands for, a place where from the product is originated. The product has the particular characteristic attributed because of its place of origin. And that is important, the place of origin, and by its name it has been recognized. The people from that area only has an advantage to use the name associated with that. Other people cannot use that. For instance, there was a legal fight between the Odisha and Bengal over the Rasgulla. Who owns the Rasgulla? It was only the Bengal who was later on. There was a fight between the Tirupati temple and the traders associated around that. Who can use the particular name of the that particular prasad laddu of the Tirupati? Who can use only the Tirupati Pandit can sell that laddu as a Tirupati prasad. No other because a lot of people started preparing similar type of the laddus and selling, but yeah, TTD that Devasa, that trustees got this particular tag to use this particular tag there as a Tirupati Laddu. Other people are not allowed to do that. Similarly, you can find out the number of products, not only the man-made products, but also the agricultural products has been part of that. You know, don't know all details of this. You can name it and you will find out in India at present we have around 550 products which been registered as a geographical indication. There is a tag of a GI, no other one. In fact, as far as the Puneri Pagdi is concerned, it is also registered and protected under the TA, under this particular tag. You can identify something in and around Vidarbha region also, something to protect it. Then next step of the industrial property is design. Design is nothing but an ornamental or aesthetic aspect of an article. It may consist of a three-dimensional features such as shape or lines, shape or surface, or two-dimensional features such as the pattern of lines or a color. So the design of any product, whatever product we are using, as it has been mentioned here, the design can ranges from the different products such as handicrafts, watches, jewelry, fashion, other luxury items, industrial and medical implants, housewares, furniture, electrical appliances, vehicles, architectural structures, textiles, designs, toys, etc. Whatever things comes that has been registered as a design. There is design of anything, as it has been mentioned, the architectural structure. Even the design of a Taj Mahal it has been considered as a unique one, and India has protested several times to reproduce the replica of a Taj Mahal. There is not only one Taj Mahal existed in the world today; it is around eight different Taj Mahals are present there. In Dubai, it is there. In different colors, it is there. But in India, we have at least two Taj Mahal, two, one replica of Taj Mahal is there. One is at Aurangabad and other one, original one is at Agra. So Taj Mahal is a quite old one in the sense we have the examples of that to protect it in the sense of a design. But there are other instances, other buildings which is also been protected as a design there. Nobody can reproduce identical design buildings. Uh, Design of anything as it is been mentioned here, the design is nothing but the two-dimensional feature or three-dimensional feature. Three-dimensional feature includes the pattern of lines, sorry, shapes, where it is. Three-dimensional features such as shape or surface of that particular product, or two-dimensional features, even the pattern of lines or colors is even considered as an aspect for the registration of a design. Design of two products are never identical. For instance, if you take an example of a biscuits, you will not find the two biscuits identical, although the shapes of that are identical. But you will distinguish between the two biscuits of two different brands in different sales. All biscuits has its own design and it has been registered with their name. So that's about the design. Design is considered as an intellectual property to differentiate the product, one product from other product. That is why the design has been considered. Then we'll come to the most important form of the intellectual property, or most important type of the intellectual property, what is been called as a patent. So, as you are having some patent applications or somebody of you are holding patents, then what for the patents has been obtained? If we ask you that design protected by the design application, then if we take an example of a trademarks or the trade signs is been protected by the trademarks, then what the patent protects identically? What for the patents are there? If we take if we say something that I have a patent, what it means? Any one of you? What for the patent? What form we obtain the patents? What patent protects actually? What is being protected by the patent? This very basic question that what is being protected by the patent or what for you get the patent. I'll tell you what is the patent, what for the patent is, what is the right obtained by the patent, but what for you obtaining? What what for the patents is being get, obtained? Why government gives you the patent? What you have so you get the patent? You hmm? दुसऱ्यांनी मिसयूज करू नये म्हणून त्यासाठीच मी आलो सांगायला की तुम्ही टाईप बनवलं नवीन तर तुम्ही प्रोटेक्ट करा दुसऱ्यांनी तो यूज करू नये तुम्ही स्वतः ते यूज करा पण कशासाठी पेटंट मिळतं हा आपण जे थोडं 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 हा दुसरे हा हे ठीक आहे पण कशासाठी पेटंट मिळतं पेटंट कशासाठी मिळतं आणि पेटंट राईटने काय प्रोटेक्ट होतं सर तुम्ही पेटंट कशासाठी मिळतं तुम्ही नाही इनोव्हेशन खूप पलीकडे झालं थोडं अलीकडे पाहिजे होतं राईट साठी ठीक आहे ना राईट घ्यायसाठीच आपण पेटंट घेतो पण पेटंटनी काय प्रोटेक्ट होतं जसं डिझाईन प्रोटेक्ट होतात ट्रेडमार्क्स ट्रेड सिक्रेट किंवा ट्रेड नेम्स प्रोटेक्ट होतात किंवा ट्रेड सर्व्हिस मार्कनी सर्व्हिसेस प्रोटेक्ट होतात ट्रेड सिक्रेट्स प्रोटेक्ट होतात कॉन्ट्रॅक्टनी तसं पेटंटनी काय प्रोटेक्ट होतं पेटंट आपण घ्यायचा प्रयत्न करतो किंवा पेटंट मिळतं म्हणजे नेमकं काय होतं फक्त नॅक मध्ये पॉइंट्स मिळतात एवढे नका सांगू बाकी सगळं सांगा तर नॅक पण का पॉइंट्स देतं you get the rights to use that thing, but what that thing? I just want to know what for you get the patent. What is that? So government say that okay, you have the patent right, stating that you can exclude any other person from manufacturing, using, selling patented product or patented process without due permission. I told you that what right you get by patent, but what you protect by having a patent? Invention. You protect your invention by a patent right. How you protect it? You protect it by excluding any other person from manufacturing, using, or selling the patented product or a process without due permission. How long you get this right? You get this right for 20 years from the date of application. It means that if you file the patent application today, then you get the right to exclude others from manufacturing, using, selling the patented product or process from using without due permission. It's up to 20 years from the date of filing of the patent application. But what is the invention? You get a patent right for the invention. Innovation is nothing but utilizing invention to create something that is innovation. But what is the invention? You get a patent right for protection of an invention, and the patent right is nothing but to exclude others from manufacturing, using, selling the patented product or process without your permission up to 20 years. But now question is that what is invention? जे अस्तित्वात नाही ते शोधून काढणे कसं काढणार जे नाहीच ते कसं शोधणार तुम्ही discovery is something that which is finding out something which is already existed in nature but not known नवीन संशोधन पण काय ते ओके इम्प्रुव्हमेंट झालं त्यामध्ये इम्प्रुव्हमेंट पण नेमकं काय पेटंट इन्व्हेन्शन करतो म्हणजे नेमकं काय करतो आपण इनोव्हेशन झालं मी सांगितलं युटिलायझिंग इन्व्हेन्शन और employing an invention for in actual life is innovation. But what is an invention? Huh?
नवीन संकल्पनेचा शोध.
It is nothing but an idea. It's
नवीन संकल्पनेचा शोध.
terminology or new product. Invention stands for a new product or a new process. What for you get the patent right? Patent right you get to exclude others from manufacturing, using, selling the patented product or a process. Patented product or a process without new permission. That means the invention is nothing but very simple a new process or a product. New product, how the new product is that you take an example of any product, you modify it, or you make a positive change, or even you modify it, you make any change into that, you add this economic value to that. That's it. That's a new product. For instance, a very simple example of a tea, if you are taking, if you take a plain tea and you add certain spices into that, like a cardamom, or even nowadays you can add a ginger. Then the tea without ginger or without cardamom is a different tea from the improved tea. That's a new product. Even nowadays the feature has been added into tea, so that is a different tea. That's a value tea than compared to the normal tea. So it's a new tea. It's a new product. And the process, preparing any product or any process, preparing any product is the process. How you prepare it, the process. Earlier I was the example of what that tea is called, tandoor tea. How many of you have heard the word tandoor tea? How is it is been prepared? The tea is normal tea, like our tea, but there is a disadvantage of repeatedly heating it and using it. The taste changes drastically. It may not be acceptable sometimes also if you heat the tea twice. So there is a different way of heating the tea by in the tandoor tea, where actually cup is kept in the tandoor, and then you put the tea into that hot cup and then shift it to the normal cup to take it. How the tandoor tea is been prepared. So that's why how you prepare. The process is that how you arrived at a product, whereas new product is an improved product or a different product compared to the earlier one. So the concept is clear. New product and new process. The new product is an improved product or any other product or process. How you arrive at that. The subject matter for the patent is an invention, and the invention is nothing but a new product or a process. But when it comes to the patent, the definition will become a slightly difficult in the sense it's not only a new product or a new process. It's having an inventive state and useful in industry. Inventive step is that concept under which the modification you carried out, the changes we have carried out, it's not obvious to the persons, not obvious to the group of people. It must be out of box thinking. It must be an improved thinking. It must be a different thinking from the other that is resulting into the improvement or adding value to the existing product. So that thinking is called as an inventive. That concept is called as an inventive state. That is the inventive state. So what is the definition for the invention? Invention is nothing but a new product or a process having an inventive state and useful in industry. It means that only it is only new thing is there. It's not meant for the patent or inventive thing is there. It's also no. It must be useful in industry. It is in the sense that it is utilized. It is commercially useful. It must be result into the it must be result into the commercial improvement. It must be resulting into the generating money out of that. So that is where the concept of a useful in industry comes. So what patent protects? Patent protects the invention, which is nothing but a new product or a process having an inventive step useful in industry. And what patent rights are there to stop other or to exclude other from manufacturing, using or selling without due permission, either it is a patented product or a process, and it lasts up to the 20 years from the date of filing of the application. And if you see the definition of the word patent, it means that the government is actually telling you that come to the patent office and disclose what you have. That means you disclose the patent, your invention to the patent office, over which the patent office or the government grant you the exclusivity to exclude others from manufacturing, using, or selling up to 20 years. It can be a patented product or a process. Is that clear? This for the patent rights are there. If there is any specific questions about the patents, then we'll take it later. Let me finish up this. This is about the topography of integrated. Those from the physics or the electronics, they may easily understand what is the topography of integrated circuit or what is the layout design of an integrated circuit. If you have opened any electronic article or a gadget, then you will find on motherboard there is a particular fashion. All electronic components are placed there, and the technical effect is because of the particular placing of the electronic components on the motherboard, and the design of this is called as an integrated circuit. These integrated circuits are protected as an intellectual property because the technical effect achieved because of the placement of these electronic components over the motherboard, and that specific technical effects has been protected as a topography of integrated circuit or layout design of an integrated circuit. There is a special act to protect it in India. Its registration can be done at the patent office itself. It's like an ethical to the trade secret, the undisclosed information. It's been protected by the between the agreement between the employer and employee. We'll not go into details of that. This is one very important, and this is another type of the intellectual property. As we have seen that the intellectual properties are of two types. One is the industrial property, and the other one is the copyright. Industrial property is categorized into the trademarks, trade secrets, service marks, geographical indication, designs, then patents, topography of integrated circuits, and disclosed information. Whereas the copyright or the copyrights and related rights are the two different things. This is also considered as a copyright. The word copyright is very familiar to all of us, but hardly we know that what is being protected by the copyright. The copyright protects copyright gives the creator of the original work exclusive right to usually for a limited time. Copyright may range to a wide range of different types of a creative, intellectual, and artistic form of the work. We'll see what are the different types of the work. These different types of works are not in the field of the are in the field of the literature, music, art, and audiovisual work. Copyright is generally obtained for the expression of the ideas and not the ideas per se. Copyright is made for the protection of the expression of the ideas and not the ideas. If, for instance, for literature work, you get the copyright for the all literature information, literature information either it is in the form of book, novel, magazine, or any digital form of the literature which document there. Then artistic forms, maybe painting, photography falls into that, or the drawing pictures falls into that. That is protected there. Art, sculpture, the drawings, paintings falls into that. Audiovisual work, any audiovisual work, for instance, any movie or audiovisual movie or songs comes under these categories. This is been protected there. So this has been protected by the copyright. The copyright is for the expression of the ideas and not the ideas per se. The copyright of the original copyright remains with the creator of the original work. For instance, somebody has written a novel in Marathi, then its right will remain with the original author who writes that novel in Marathi. If there is a translation from Marathi to Gujarati or to the Orissa or some other language, still they need to seek the permission of the original author, that is who has been originally written it in Marathi. If there is an adaptation of this particular particular novel into the drama or a movie, In that case also you need to seek a permission of original author who has been penned down the entire story for that. Even though there is a change of medium or change of form from literature to a drama or drama to a digital form, still it needs to the copyright is usually called as a bundle of rights in the sense that when anyone owns the copyright, for instance, on the audiovisual work, then he owns the bundle of right means he owns the right of a literary person who has written the story for that, performers who have been performed over that songs, then a sound audio work who has been recorded that, and the collectively being is the owner of this right. So it has been called as a neighboring right or the ownership or a related rights also. That is why the copyright is so important. You can seek the copyright over any literature information you have been created, right from your lab book to the any article you have been written for the college purpose. You can seek copyright over that. And for registration of a copyright, you need just 500 rupees to register the copyright in the name of a person who written it. uh, you can do this process online to register it from the Register of Copyrights website. Simple registration is there. No digital signature is required. Only simple login and paying fees is important. But the registration of copyright is although not compulsory or mandatory, but unless you register it at the copyright office, it has been not considered as a valid evidence under the Copyright Act. That is why it is necessary to write to have the registration of the copyright. Apart from that, what else? So this is about the brief introduction to the intellectual property rights. As I told, the intellectual property right. What is the concept of the intellectual property right? Property right. It's a protection of a creation of a mind. Creation of a mind having a legal ownership over that. Intellectual property rights divided into two main classes: industrial property and copyright or the related rights. Industrial properties includes the trademark, trade secrets, service marks, then designs, geographical indications, and patents, undisclosed information or the layout or topography, whereas copyright and related rights is for the creation of a human mind in the field of literature, art, or the audiovisual. That's it about the. Thank you very much for listening. Thank you. Thank you.
So, dear participants, if you have any queries, any question in your mind, please ask. The workshop is open for discussion. Any question? Yes, please.
To the patent office website, whatever research you are conducting, it's not audible. Whatever research you are conducting, you read your own areas patent applications. You will get n number of different ideas out of that for your own research. Not only as I was telling sir that let's have a dream to start a startup in a year time from your own ideas. That ideas will come from the patent applications. Patent applications is a good source of an information. Your research people are very less or maybe a fraction of that. You just read some of the patent applications and change the way research is being carried out. You will find out there is a change. There may be a commercial aspect comes to the your research also. You'll understand the world differently when you read the patent applications. You will understand how the research is being commercialized. The idea about sensitizing the academicians about the intellectual property right is that the way they look to the research, we need to change about that. We need to have the commercial aspect of that. You read of your own field, whatever field you are working, maybe in the physics, chemistry, or biotechnology. You read your own field patent applications and call me in 10 days' time. After reading a 10 patent applications, you will have n number of different ideas in your own name. You can file a very good project, not only the DST, CSIR, you will file all the financial institutions where you can do it. He may be probably proper guide you to that, do that. For filing a charges for filing a patent application. Patent for filing, how many fees is required? As I suggested you to visit to the patent office website, there is a column for fees also. If you learn something on your own and do something on your own without taking help of an advocate or without taking a help of a patent agent or a patent attorney from Pune or Mumbai, then if I tell you filing a patent application, you require just more less than 2000 rupees. It will require less than 2000 rupees to file the patent application. It is a 1750 exact amount required to file the patent application. You don't need to visit to the patent office for that. You just draw a demand draft in the name of controller of patent and send it by courier. If you are more advanced, having your own digital signature, you can file online application. You can file online application provided that you have a digital signature to do so. If you're not having, then still you can file application without going to the Mumbai. You can register, you can have the demand draft and the fees there. This 200 rupees is the basic fees required to file the patent application. Apart from that, next two fees which I am telling you, it's an optional fees, one of that, and one you can file up to the 4 years from the date of filing of the application. The other fees is called as a early publication fees or early publication. In that fees, that is 3750 is the fees for that. It is optional to file it. If you want your application published in a 1 month time, then only it is need to be filed. Otherwise, it is not necessary to file this particular fees. Else also, your application get published at the patent office website or the patent office journal in 18 months time from the date of filing of the application. File the fees of 1370 for early publication. In that sense, only it is required if you want to publish it within 1 month from the date of application. If you are not in a hurry, you can wait. You can wait up to the 18 months. You don't need to file 3750 rupees.
whereas you need to file 4,400 rupees fees as a examination fees, but that is not necessary to file it right now also. You can take 4 years of time from the filing of the application today. You can wait up to the 48 months from the date of filing of the application to take your application to the next stage. If you still not file the 4,400, still your application will be published in 18 months time. But if you fail to file 4,400 rupees after 48 months, then your application is automatically get withdrawn and it will not be in further process. So that much of the fees is required for filing the patent application. It's a 2,000 rupees must, 3,750 and optional, 4,400 rupees. In a 4 years time, you take a decision over that whether to file it or not to file it. That's it for making an Indian patent application. That much is the only fees is required. Yes, sir.
If someone wants to publish Indian patent and German
You want to publish in journal. If you file a patent application today, tomorrow you can publish it in journal. There is no bar for that. In fact, in your journal publication, you write that you have filed patent number, patent application, and having it so and so number. It's like an advertising that you have the patent application over there. It's like that you are deterring the others from not utilize this particular technology without your permission. You have a patent application. Use it.
Saying that whether to file in India, patent application or file in Germany, which one will be better?
Let me tell you in that patent rights are territorial rights. That means if you file a patent application, its rights are remain in India only. You cannot enforce your right in Germany. To own a German patent application or to own a, what is it called? To own the patent rights in a Germany, you require at least a budget of 5 lakhs rupees to have it because you need to go through the European Patent Office and the fees for European Patent Office is not less than 2 lakhs rupees. So where you are going to sell your patented invention in India or in Germany? If you are using your invention in India and you want to protect in India, then you have to file patent application in India only and you have to protect in India. There is nothing that you can go, you have a patent in India, that means you cannot protect your patent right. Even in Sri Lanka, Germany is far away. So it's a territorial right. Whenever you make an application in that country, it's actually having a patent or doing making a patent application is a commercial decision. It's not a stake that only we get some points at some grading agency, so we have keep it on filing the patent because it is for a generation of a revenue. Why we need to file the patent application or protect our invention in Germany? It's better to have it in India and own it. It's like having a ownership in that particular country over that invention. Are we able to? What is the purpose of protecting invention in Germany when we are using the invention in India itself? So patent is a territorial right. There is nothing like having a patent in Germany or even Pakistan or Sri Lanka or Maldives or even in Nepal or not even in Bangladesh. There is no use of that. Most of the academicians come these days. There is a very easy way to get the registration in Australia. They boast themselves to I have a patent in Australia. But what's the use of that? Your invention is not useful in your own college. Then why you are doing and having the patent in Australia? You are not going to protect your invention. What for patent? As I told you that the patent rights are to protect the invention, to protect the invention from copying it by other, because government gives you an exclusive right over that. Have the commercial aspect to that. Spending for I think almost $1,000 required in Australia. You are spending almost 50-60,000 rupees to protect your invention, to protect your invention in Australia. What you are gaining out of that? Except some good work from the principal uh, or some credit points, but the 70,000 rupees is too much for that. So the idea of having a patent that you are utilizing that patent in India. simply the invention of a cooler tea is a commercial idea. If you start the outlet in and around, if you develop that technology and give that technology, only how many tea outlets are there nowadays? All the branded tea outlets are coming out. This is also one of the good thing that in an Akola only you'll find out at least 50 outlets coming out of that, generating a revenue of at least 15-20,000 rupees pure profit at the end of the day. So what for the ideas are? Ideas to generate the money, because patents has been seeing from that point of view. It's not only the academic aspect to that. It's a commercial aspect to that. Because owning a patent itself, if I'm not telling you the exact price of the patent, how much money is required or how many money is been there, you call at Pune and find out that what the patent agent or patent attorney's cost. It must be not less than six-digit figure. So what for we are getting patent, that is more important, and that is the purpose why I am here to sensitize all of you. Thank you. If anyone has question.
Thank you, Kulkarni sir, for sensitizing our mind with the intellectual property rights. Now I request President of today's function, our Honorable Principal, Dr. A.L. Kulkarni sir, for his addressing students.
Today, so one day workshop on intellectual property right is organized here. Just for this. So here the resource person, Dr. Suhas Bikari sir, is from Patent Office Bombay, as well as Dr. Aniket Gade sir, who is from Santa Garge Baba Maharaj University of Geography. So here on the dais, so coordinator this workshop, Dr. Vikar Puchi sir, as well as the IPC coordinator, Dr. Ashish Saud sir, and all my staff members and the students. So here, so most of the faculties, as well as most of the faculties and all the students. So here, most of the faculties and all the students are unaware about the process of the this patent. And so here, this concept is also not well misunderstood by most of the faculties and by all the students, because students are unaware about it. These faculties are also. So here, I get pleasure that our college is a multi-faculty college. It's one of the lead college, and so we are with a college with a potential excellence. So that's why, and so we are in number of subjects. So there are the PG courses and this research, these programs. So that's why most of the faculties are well aware about the patents. As you the copyrights, patents, as well as trademarks. But now here the faculties from the colleges, other colleges. So here this where this only the course programs in humanities and commerce and management are running. So they are completely unknown about it. So that's why here really sir, this your lecture, this has been is fruitful to all of us, because so this concept which is well is explained as well as understood is by all of us. So here and so here intellectual property right, we know the property, other properties. So for that land, um, so land is house. So here Bangalore. So other we most of the people are well known about these words property. So here this is the asset, but now here intellectual property is also our asset. Innovation as well as our creations, as well as the so here particular ideas these are protected in this by these rights, and so here these inventions are also so
by this law, by this patent, this will be protected. So that's why here, this by process, we should know this about it, this in detail, this explain it. And now here, on the other hand, if one of the if any faculty is coming forward, is to file this for the patent, to, to file an application this for the patent, and if the institutions as well as the college will get the benefit. So here, this all these guys, I declare that this all the this charges this will be sponsored this by the college. So here, this free all charges, free all charges will be sponsored this by the college if any faculty is going to file an application for it. So here today, so you have given the this very detailed information, and Dr. Rade sir, this introduced the resource person, and here by very hectic this way you have been reached here. This we can understand that means from Bombay to Akola and by train, not by train but by Mr. Bus. Means you have been reached here. Really, sir, you have put a lot of efforts to come here and deliver this very fruitful this information to all the students as well as staff. So on behalf of this college, I welcome you and extend my thanks. I stop here. Thank you. Thank you very much.
Thank you, sir. I request all the online participants, you have to fill the feedback link for your certificate as well as your feedback is important for us. Then I called Dr. Koche for the vote of thanks.
Hello everyone. Honorable Dias, Honorable Principal of our college and Chairman of this workshop, Dr. Pulat sir, respected Chief Guest, Dr. Suhas Kulkarni sir, Guest of Honor, Dr. Aniket Gade sir, respected IPUSC Coordinator, Dr. Ashish Raut sir, all IPUSC members, all the head of the faculty, all head of different departments of our college, student participants, and all present offline and online to attend this workshop. So we are entering in the new era of education henceforth with the new education policy 2020, probably from the next year or from near future. And there is no scope to flourish to any education institute without research and without sizable research output. Considering this fact, we have organized this workshop for the faculty members and the research students and PG students. I sincerely thanks to our principal, Dr. Pulat sir, for supporting in conducting this particular workshop. I also extend my thanks to today's research person, Dr. Suhas Kulkarni sir, for his lucid presentation and interactive session on IPR awareness. Thank you, sir. My special thanks to my friend Dr. Aniket Gade, Coordinator IPR Cell, Santa Gadgibaba Amravati University Amravati, for coordinating this event successfully. My thanks to our IQAC coordinator for excellent welcome speech and all the respected IQAC members for their support and in the organization of this workshop. I express my sincere thanks to all the head of the departments, faculty members, and all the participants, because without their attendance and participation, this would not be a success. I also thanks to Dr. Hemant Sapkar, Dr. D.S. Deshmukh, Mr. Shubham Rathod, and his technical team for playing their role very nicely to make this event successful. Again, I thanks all those who have helped us in organizing this particular event, directly or indirectly. Thank you everyone. With the permission of chair, I declare here that the workshop is over.